And I will start by giving just an interaction that I had with one of my clients about 2 weeks ago. She sent me a WhatsApp message. And in this WhatsApp message, she was saying essentially that her mom has been a lawful permanent resident of the United States for more than 10 years. And she's seriously contemplating applying for US citizenship, having her mother apply for US citizenship. However, she was doubtful about investing $725 to pay the government for this so that she could go through the process and acquire US citizenship. So she sent me the message, and she said she's doubtful about the investment because she's hearing, information from different sources where they're saying that President Trump has set up this task force to go through the files of persons that have been naturalized, that have become naturalized US citizens, and they are, based on her impression, they are randomly taking away citizenship from people that have acquired it by way of naturalization. However, there's no way that I could discourage you or discourage your mother from submitting an application to obtain US citizenship, because it is very important. It's the most important immigration status in this country. And her response to me was to actually send me a voice note message via WhatsApp. And in that voice note message, there was a gentleman. The gentleman was dressed very professionally. He is a Caucasian and very charismatic, very expressive, very articulate. And he was saying that yes, Trump is stripping people of their US citizenship, and there's this task force and it is reviewing the files of persons that have acquired US citizenship. And the impression that he gave in terms of expressing the information was that the government was just going around and randomly taking away citizenship from persons. I explained to my client via the same WhatsApp message. I told her, in spite of the fact that the Trump administration has a strikingly different way of enforcing US immigration law from previous administration, the laws of this country, or the federal immigration laws, have not fundamentally changed. Since 2016, Congress has not passed any new immigration law to my knowledge. So the laws as they are on the book is still fundamentally the same. The Constitution is also the same. And the Constitution essentially says that US citizens have the fundamental right to due process. Now, the due process provision under the Constitution essentially says that your life, your liberty, or your property cannot be taken away from you without due process. So within the context of immigration law, if you have acquired US citizenship by way of naturalization, the government cannot now randomly come and say, okay, we're just going to take this away from you. It does not work like that. You must appear before an immigration judge. You must go to court. And in going to court, the other issue is that the burden is not on you, the person that has US citizenship by way of naturalization, to show that you properly acquired it. The burden of proof is on the government to show that you improperly acquired US citizenship. So the burden, like I mentioned before, is on the government to show that, well, we have information that you lied. For example, in completing your application for US citizenship, let's say you have a disqualifying criminal conviction. And by that I mean, let's say in the year 2000, you had a conviction for selling drugs, which is considered as drug trafficking. Within the context of immigration law, that's an aggravated felony offense. And if you committed that after the year 2000, after 1990, that could potentially, that will make you ineligible for US citizenship. So let's say you complete your naturalization application and you know about this conviction, and in completing the application, you fail to acknowledge that you had this conviction. And let's say by some rare chance which is highly unlikely to happen, but it could potentially happen. Let's say you do your fingerprint, your biometrics, and it was not discovered that you had this prior conviction. And the government, not having seen that you had this prior conviction, now grants you US citizenship. And the question is whether you can become denaturalized because of that conviction. And the answer is yes, you could potentially be denaturalized. Because the government, in establishing the burden that you acquired it illegally, they can proceed to denaturalize you. Again, I must say, however, that this is highly unlikely because the level of scrutiny that an applicant for US citizenship goes through to obtain US citizenship is very, very high. Right? So in terms of background checks, in terms of vetting your application, it's very, very intensive. So I try to convey this kind of information to the client to let her know that yes, by all means, go ahead, submit your application, submit your mother's application for US citizenship, because it's very crucial in terms of an immigration status, having that kind of immigration status, not just because it spares you or protects you from removal, but there are certain mean-tested public benefits that US citizens are eligible for that non-US citizens are not. So I try to reassure her that acquiring US citizenship is still very important. And I, just for the listening audience, for persons who are sitting here, to recognize that it is so crucial. If you have the means and you can do it, definitely, I strongly advise you to do so. Right? I don't want persons to be sitting on permanent residency for 20 years, and because they're indifferent, or they are considering the fact that, well, they will have to renounce loyalty to their home country or previous country of habitual residence and now become US citizens. That is something that I say, well, you are here, you've been living here in the United States for this long, why not take advantage of obtaining this particular status? You have contributed to the development and growth of this particular country, why not get the status that is emblematic of your contribution then to this great nation? Right? So now I'm not going to overdo it in terms of just talking. So I just want to open up the discussion to you guys. If you have any concerns, any questions regarding immigration, I'm here. I'm willing to speak to you on the subject if you have any concern.
For instance, you have a brother or a sister, and you file for them. How long will it take now? Under Trump presidency.
Okay. Well, I must acknowledge that since 2017, based on my experience as a practitioner of immigration law, what I see is that applications are taking longer to process. Yes. So typically, however, once a U.S. citizen submits an application, an immigrant visa application for sibling, brother or sister, typically I'm looking at between 10 to 13 years for a visa number to become available, and it can even be a little bit longer. So yes, it is taking a long time, but at the same time, I would not discourage you from submitting an application for a family member like your brother or sister, if they are eligible to receive that benefit.
What about children?
In terms of a U.S. citizen submitting an application for a child?
Yes, U.S. citizens making an application for a child over 20.
Over 21?
Yes.
Right, because the age of majority within the context of immigration law is 21. So once you pass the age of 21, you're deemed an adult. So a U.S. citizen submitting a petition on behalf of an adult son or daughter, it can take more than 6 years before a visa number becomes available. And we know that if it's a situation that you file an application for an adult son or daughter, those petitions once a visa number becomes available, those petitions or those cases are normally forwarded by the State Department to the embassy or consulate in which the beneficiary is living. So if you're here in the United States, you're a US citizen, and you're filing a petition for your adult son in Jamaica.
In Jamaica, yeah.
Right? What typically happens is that once the visa number becomes available after the I-130 or alien relative petition has been submitted, and of course you wait that 7 years, let's say, then the case is forwarded to the embassy there in Kingston.
7 years.
Approximately, give or take. Right?
Thank you.
You're welcome.
How long would it take for a child to file for their parents?
Persons under 21 can't petition for anyone because they have not reached the age of majority. They need to be 21, right? At that point in time, they are considered a son or a daughter submitting a petition on behalf of a parent, right? Usually, it's a much shorter period of time because the law stipulates that immediate relatives of US citizens do not have to wait until a visa number becomes available. So unlike a situation where a US citizen is filing a petition for an adult son or daughter, where you have to literally wait until a visa number becomes available, in the situation where you have a US citizen petitioning for a parent, a US citizen that's old enough, of course, just 21, to petition for a parent, the visa number is immediately available. There's no wait time. The only wait time is procedural time or administrative processing of the case itself. So once that alien relative petition goes in, it depends on the time period that the administration, and in this case, the Department of Homeland Security is going to take to process that application. And now, typically within this jurisdiction here in New York, it takes around 6 to 7 months to process an I-130 application. After that I-130 application has been processed, then the case is sent to the State Department. The National Visa Center, which is in the State Department, will then ask for certain documentation, such as civil documents, birth certificates, passport, copy of the biographic information in the passport, pictures and police certificate, right? Once that has been received, they will typically forward the case. If it's a situation, I should say, if you're filing for someone, the parent that is outside of the United States, in that case, the case will be sent to Jamaica or wherever that the beneficiary is living, right? However, the immediate relative filing for a parent who's here in the United States, they can stay here and adjust that. So once the I-130 is submitted, or the I-130 could be submitted simultaneously with the application for adjustment of status, and all of that is sent in one package to the Department of Homeland Security, and then they process the application, right? Before 2017, that application would typically take approximately 6 months, but since the new president came into office, it can take as much as 23, 24 months to process an application for adjustment of status. And here in New York and California, it might even be a bit longer because of the volume of applications coming from this particular jurisdiction.
The city have an ID that they give people, which you can only show it in the city or use it in the city. But when you go on to government property, that is no good.
Yeah,
So he got arrested, but I have a question. He has 2 American kids. He's married to an American. How come he's taking so long? How come he's still a fugitive? I mean, did she file for him or did she not file? It doesn't seem like she filed for him.
To my knowledge, based on what I heard from the media, I'm not privy to any information than you, is that this gentleman was previously ordered removed from the United States. So there was a previous removal order.
Right.
So if there's a prior removal order there, even though you have a U.S. citizen spouse who under normal circumstances could submit a petition for you to facilitate your adjustment of status to become a permanent resident, lawful permanent resident of the U.S., the prior removal order is going to hinder that process from taking place, because that must be addressed, right? So I believe that particular case there was a prior removal order that had to be addressed before the wife could go ahead and even submit an application to facilitate permanent residency for her spouse. The ID that you mentioned here, which is a New York City ID, it's not even a state ID, right? It's not something that I encourage my clients. Listen, do not use this ID to travel outside of New York City. If you intend to take a plane, do not use it to travel interstate, to travel from New York to Florida, or to travel from New York to Maine, right? Because then you run the risk of, TSA agents or federal agents, saying that, well, this form of identification is not acceptable. They may run your prints and discover that, well, you're unlawfully present, you're undocumented immigrant living in the United States. And that, in and of itself, is in violation of U.S. immigration law, making you susceptible to deportation or removal. So again, there are a lot of issues that persons out there are unaware, and I believe it was the mayor did in fact try to explain, and I don't know whether the information was communicated with, the information was disseminated enough so that persons can recognize that the ID is a municipal ID. It's good within the city of New York for conducting certain transactions, supposedly. But when we're talking about this as an official ID for federal purposes, I would strongly discourage persons from attempting to use it.
I think when they first started to talk about this particular type of ID, the way it was presented that you could have traveled out of the U.S. with this particular ID. So I think people understood that they could go anywhere with the ID and not get in trouble. And I also was told that this ID, you could do transactions. I particularly cannot even use the ID to go visit my clients in the institution. They will not accept that type of ID, but I was told that I could have used the ID because the only ID I have right now is my passport. So I thought that if I got the ID, I could make things easier for me and don't walk with my passport. But when I tried to use it in the institution to go visit my clients, I was denied entrance. I wasn't able to see them because they would not accept the ID. So I think that when they started to present this particular ID to the population, maybe it wasn't presented right or people misunderstood the way it was presented.
Right. I believe that could potentially be one explanation as to why there is so much confusion regarding the municipal ID and its use as to what we can use it to or what we can't use it to do. And I think...
And the bank don't use it. If I take it to the bank, they're not using it. No, they don't use it. And I take it to other places and they don't use it. So why give it? Because we have no use, that's waste some money too. It is.
It's the New York City Municipal ID. No, it's not a state ID. No, it's not a state ID at all. It's specific to New York City. So once they're doing transactions, maybe within the bars of Brooklyn, Bronx, Staten Island, Queens, within New York City.
You use it for the library, you use it for the park, you use it for the museum, where you can get discounts and different things.
Right.
But it was never stated that you can use it to go out of the country. They're now issuing passport cards along with your passport that has everything, but if you're not taking the plane, you can use a passport card. People will go to the airport and they say, I have a passport card, but you will still need that book.
Right.
So they can stamp it. On land, you can use a passport card. So people are still confused, a lot of persons, whereby they have the card, so they figure, if I have the card, I can go to Kennedy and I can jump into, Pearson in Toronto. No, it doesn't work like that. Or you can't go to Jamaica, Guyana, Barbados, or wherever with a passport card. If you're going by land and sea, yes, you can. But if you're flying, then you need to use your passport book. I have a question. You were speaking about when they make application for parents or vice versa. I know that in most cases what I've heard was that one would have to provide, let's say a parent is applying for a child outside the country, that DNA test is also required to show that this father, or sometimes if the mother, this lady, might say, I'm applying for my child. But does it work the other way? When the child is, applying for a parent someplace to prove that this is your real biological parent?
Absolutely. There are instances where a son or daughter who's a US citizen submits a petition on behalf of a parent, and they are required to submit DNA evidence to establish that there's in fact biological, can be scientifically established that this is your biological parent. Yeah, so it does, it does happen as well. So it not only happens in the situation where a parent files for a child, it also happens in a situation where a son or daughter is petitioned for a parent. Right, so it does. Again, it's a discretion, and also it isn't typical in the situation, primarily when you have a mother submitting a petition on behalf of a child, because usually maternity is easier to establish. Establishing that you are in fact the father of a child is harder to establish. Oftentimes, especially among Jamaicans, sometimes on the birth certificate, it's only the mother's name that's listed on the birth certificate. And sometimes the birth certificate that they're submitting has been amended. And you can see that, well, this birth certificate was amended on the child around the time that the child turned 16. And then that will cause the State Department, that will cause the local embassy to question whether or not this is in fact the real biological parent of the child. At that point in time, they may request DNA evidence.
But isn't there a fact that way back then, past practice historically, let's say in Jamaica, this lady might be fooling around with enough persons. She gets pregnant, she doesn't know who, but it's Tom Stroke, so Tom Stroke name goes there. And he lives forever taking care of this child. But later on in life, he's in America, Canada, or wherever, and applies for this person. And the next thing you know, big thing, not my child.
Right.
Because even though for 20 years or 18 or whatever, this was my child. But when the DNA takes place, then...
Yes. I've seen instances where it still works out though, even though the DNA test demonstrate that this is not the biological father of the child, but because there was a marital relationship. So the supposed father was married to the biological mother, before the child turned 18, then there's a legitimate step-parent relationship that has been established. So the application is able to proceed on the basis that a step-parent is now petitioning for a stepchild, right? But yes, it's very awful, and a lot of persons have been affected by it, especially in the situation where you have a supposed father, or alleged father, taking care of a child right up until the point of them becoming adults.
Yes.
Right? So it's hard. It's very traumatic in many instances.
Somebody made an application, let's say an elderly, a mother,
Right.
for a son or somebody, but in the midst of that person passes, the applicant. What happened?
Once the petitioner, right, dies before that beneficiary is able to receive that immigrant visa, that application also dies. That's the general position. However, there is an exception to that particular rule, whereby the government can allow the application to proceed if it can be demonstrated, if the beneficiary can demonstrate that there are compelling reasons as to why they should still get this immigrant visa to come to the United States in spite of the death of the petitioner, right? So there are certain instances. Also, there's a provision too where it's a situation, let's say you filed an application. I've actually seen this with my client. She filed an application for adjustment of status on the basis that she had a US citizen son, that's an adult. He submitted the petition for her in January of, I believe it was January of 2017. And the petition was submitted, and the application, the I-130, was approved just prior to the death of the son in June of the same year, right? So the alien relative petition was approved. Now the question was whether she could now adjust status of, submit an application for adjustment of status with the fact that the son that has petitioned for her is now deceased. And the answer to that is, if she could demonstrate that she had a substitute sponsor. And now, to become a substitute sponsor, the rules are very specific. An aunt, an uncle, they can't be a substitute sponsor. It has to be closer family members. If it's a situation that you have another child, for example, that's a US citizen, and that this child is old enough. If it's a situation you have a mother-in-law, that kind of, or a father-in-law who is a US citizen who is now able to step in and become a substitute sponsor for the sponsor that has now passed away, then the application could potentially proceed. Right? So yeah, there is provision in place. It is definitely harder in a situation where the petitioner has died and the beneficiary is outside of the United States and is seeking to enter the United States, right? Because then you have to deal with the State Department and you have to mention, like I said, present very compelling evidence as to why this case should still continue. And compelling evidence is strong evidence. So, for example, if it's a situation that you have a debilitating health condition, for example, and you're the beneficiary and you're not able to receive proper medical care to facilitate, or proper medical treatment, and you need to come into the United States to facilitate that, then that could be one argument that you could potentially use. Right? I just want to make the disclaimer too that, you know, the information that I'm disseminating right now is intended strictly for, you know, educational purposes within the community. It does not establish a formal attorney-client relationship by any means, right? So I just want persons out there who are listening, as well as you guys who are present, to recognize that fact as well. It's about providing information to the community. All right?
Okay.
All right, so I think I've covered enough for today, Bishop Barnes. Thank you again for the opportunity, and thanks to you, audience, for the interaction. I appreciate it.
And thank you for coming.